13726, James M. Ryan v. Marianne Morse Healthcare Corp.
Attorney Nguyen, whenever you're ready.
Good morning, Your Honors. May it please the Court. Ivy Nguyen for Appellant, Marianne Morse Healthcare Corporation, doing business as Heritage at Framingham. The issue before this Court today is whether the summary judgment judge in the Superior Court correctly applied this Court's 2019 decision in Ryan v. Marianne Morse Healthcare Corp. 483 Mass 612. Our position is the summary judgment judge did not properly apply the directives that this court gave in that decision, and reversal of the decision on summary judgment is appropriate. In the, we'll call it Ryan 1. In the Ryan 1 case, this court determined that assisted living residents are allowed to charge upfront fees and not be in violation of the security deposit statute that a landlord-tenant relationship, that governs a landlord-tenant relationship. Specifically, if the upfront fee is tied to statutorily mandated onboarding services for an assisted living residence, that's permissible, or any other service that is designed specifically for an assisted living residence. This case was remanded.
Let's get right to it. Sorry, go ahead.
I'm sorry. So, given, I think, Justice Kafker's clear remand, that there's this limited exception outside the security deposit law. So, you then go back and engage in discovery, and the discovery that happens shows that all of these fees, these community fees, go into a central pot. And so, you know, I know that you then go in and say we categorize certain folks that worked and what they did and took percentages, and then we compared that to the community fees that were collected annually. But that's a general, even if we accept that, and even if the summary judgment judge accepted that, your specific mandate was to say, we collect these fees, and we have this limited aperture that doesn't run afoul of the security deposit fee law, excuse me. How is it that you're not specifically supposed to identify what these fees are for and then how they're spent? And you didn't do that. So how is the summary judgment judge wrong?
So there's never been a requirement to segregate or allocate community fees. And this court's Ryan 1 decision—
I don't disagree with you, but I'm saying you were sent back to do that. That's what the remand was, for you to go back. And to go back and say, well, we never had to do this in the first place. That doesn't advance the ball downfield. You were sent back to do that.
Isn't it even worse? Your CEO said, essentially, we just looked at the market and found a number that we could charge our clients. We didn't do any of it. We didn't take into account how much it costs
to do all this,
or how much it costs to do this. All we did was say, what does the market bear? And isn't that definitive, and you lose? You can't get to retroactively kind of figure it out if you just charged a number, because other people charge a number.
Respectfully, there would be, it is impractical to charge a resident to itemize the time spent.
Why is it so difficult? You've got people doing this. You know what percentage of time they do this. You did it retroactively, but that's not what you actually did when you charged this fee. You just picked a number out based on what the market would bear. That seems that's not what anyone had in mind. And you seem to have admitted that. I mean, That's the thing that gives me the most pause is you said, we just looked at what the market allows out there. We didn't calculate this. Then good lawyers like you are tried to retrofit it.
So the market is, first, the market is what would determine.
No, it wouldn't.
No, it wouldn't. It's
market.
what you're offering, what you're doing.
The market is what a bunch of vulnerable people can be charged. That's not what we said in Ryan. We said, okay, we will allow the statute allows a particular charge if it's for these onboarding services that are different than landlord-tenant stuff. Go ahead, sorry.
Can I ask get at the question from a different angle? So am I correct from your briefs that you're not defending the fourth category of purpose for which this fee was itemized as being charged for, to create a reserve fund for building improvements? I might be putting that slightly wrong, but you're not defending that that is a reason that the fee can be charged. Is that correct?
Correct, that the no community fees collected wherever you.
No, I'm not asking what did or did not happen. I'm asking, are you defending that as a matter of law that that you can charge a fee up front for building a reserve for building maintenance?
I believe that Ryan 1 would allow for a building reserve fund so long as the fund was used to pay for expenses that are ALR specific. So there are.
But have you developed an argument that here that there are ALR services that relate to the putative reserve fund such that they were permissible?
In terms of the bill for the capital expense?
Yes.
Yes. Well, so the summary judgment judge didn't get to that.
I'm not asking about what the summary judgment judge asked. The Ryan 1 decision said, here are it's itemized as these 4 kinds of costs. And I didn't read in your brief. In your brief, you say, look, we had so many of these certain kinds of costs that seem, frankly, really closely tied to the services that you're required to do under the statute. So, you're required to onboard people, and you have a bunch of staff whose entire job or a portion of their job relates to onboarding people. And so those fees, you have an argument that they relate to ALR specific services. I understand that. The other side is saying, but look, they paid for all these capital expenditures out of this same account. My question for you is, are you defending the 4th category that in the Ryan 1 decision, the court, without making any decision about it, said that this seems like a potentially more problematic category because it's not as clearly tied to ALR services? Are you, before us, defending that 4th itemized category in your bill as tied to ALR services?
This is, yes, but this is sort of that's not, factually, there was no building reserve fund, but if there was a building reserve fund and it was used to pay for updating.
That's all hypothetical. You're basically conceding there's no record before this court that capital expenditures reflected in the accounts relate to ALR services. Isn't that correct?
That's not correct. So if I can understand your question, the capital expenditure report reflects capital expenses that are ALR specific and perhaps capital expenditures that a judge would deem general landlord.
I think there's reference to window treatments and the like.
Right. So, but in that capital expenditure report, there are ALR specific type capital expenditures and non-ALR specific capital expenditures.
And did you create a record below about which ones were which?
No.
No, but there's only 2, and it's 2014 and 2018, and they are, well, in our papers, yes, but the decision doesn't have it. But can you point us to where in the record we can see a distinction? I recognize that the summary judgment decision below does not deal with this, and that's why I'm asking you. In the record,
did you put forth in front of the judge evidence regarding, to support the proposition that some of the capital expenditures were for ALR services? Specifically, as opposed to ordinary landlord maintenance of a building?
Maybe 2 points. The undisputed statement of facts, maybe I'm adjusting this from a different angle, where the monthly charges, monthly rent, capture general landlord maintenance. So landscaping, snow removal, that is captured in the monthly statement. And so
Isn't your,
That's monthly rent. That's not the community fee. Right.
Sorry.
wasn't your defense essentially that you put 100% of the cost of the director of community relations on that is $78,000 a year. You don't even attempt to do what Justice Stewart is asking you to do, which is, okay, we put in the capital reserve guardrails or handrails in every bathroom, something that wouldn't be in a normal tenant. You don't do any of that. Your defense is very simple, right? The director of community relations costs that much money. That's the whole amount, or something like that. I think that's what you do.
The defense is, it's undisputed that there were onboarding costs incurred by Heritage, and it's undisputed that those costs exceed the amount collected in community fees. And prior to Ryan 1, there was no indication to any assisted living residents that it needed to prove how a community fee was used.
Can I go back? You said that second point, that it was undisputed. Okay, that part was a function of a after the fact calculation, wasn't it?
Yes.
Okay, and so, but that after the fact, because we're within the summary judgment review here. So Rule 56 says the type of evidence that would be looked at in determining whether a party's entitled to summary judgment. That part where you did this, here are all the salaries, and somebody's going to hypothesize as to what percentage of their time is spent doing onboarding activities, right? And then you take that's what you did, right? You took the multiplier, and then you got a figure, and then you aggregated that and said, look, it's more than the community fees that were taken in for that year. Does what you did satisfy the requirement of Rule 56? Because Rule 56 says it's got to be evidence that would be admissible at trial. And after the fact, somebody just saying, I think 2% of my time is spent doing this, and then we multiply that by your yearly salary, would that qualify? You think that qualifies?
Yes, Your Honor. Well, there are the position where 100% of the time, undisputed fact, that 100% of the Director of Community Relations time is spent on onboarding.
Is that in the record? Because I haven't gone back to look at that. That strikes me as odd, that the Director of Community Relations, that's all they do is onboard?
Yeah, and that's even more odd when there's record evidence of the number of new people that were coming in, right?
Yes.
And so
know that I don't think it's odd, but yes, there is record of the number of new people coming in. I'm sorry.
So let's just take, if I can't remember 1 year, but I think one number. Can you give me one number of just one number of a yearly intake of just 1 year that you can point to? Because that part troubled me with what you just said. Just 1 year of how many residents came in?
So, I'm sorry, I'll give you the exact page. It would be, if you look at, so in our answers to interrogatories,
Was there any year that more than 20 people came in?
I think the answer, yes, but not more, no year more than, there's 98 units. So 20 25 would be a normal new.
Let's just focus on your high number, 25. So 25 people come in 1 year. They only come in once, right?
Yes.
So all of this assessment that we said under Ryan 1, you may be able to charge over and above what the security deposit statute says. That's an upfront cost, right?
Right.
So how is it that that's all that person did all year was this upfront cost, and then the resident moves in and they start doing whatever they do and take advantage of whatever they take advantage of? That's what I'm trying to square. So when you say that's 100% of what that person does, what more do they do after the 25 people moved in?
So the statute requires that any potential or prospective resident get the ability to learn about the assisted living facility, to learn about the application process, and to get their medical, to be assessed. So there are a number of people who get the services but don't end up being residents. So the director of community relations is busy dealing with people who ultimately become residents, but also that large number of people who never end up being
There you go. Is that in the record? Did you adduce that during the course of that? This is the 100%. This is not only the people we did this on the assessment, but these are the people that we did this for and then didn't ultimately sign up.
Yes, that is an undisputed statement of fact in the summary judgment record in the.
Where would we find that?
And in addition to that do we have the job description of this person in the record?
Yes. Okay. Yes. So if we look at volume 2, page 21 through 55, that goes through the description of each position, their job responsibilities, and for those who don't have 100% of their time dedicated to onboarding, we, in good faith, tried to determine how much time does this person spend onboarding, and each person that's listed touches every new resident as part of the onboarding.
I keep going back to that. How does that fit within the requirements of Rule 56? And how would that be admissible? The person, aside from the 100% of the time, the person that you divined, whatever the percentage of what they did was related to that, how would that meet the standard to suggest that the summary judgment judge should not have found in favor of the plaintiff?
The summary judgment judge failed to look at all at our attempt to. So this calculation we did was responsive to the court's Ryan 1 decision, where we didn't segregate.
Ryan 1 set out. You had stated that our community fee does these things. It takes into account onboarding, but it actually was inaccurate. Your community fee was a market survey that you developed. It wasn't what you represented. It was, all you did was, right? Am I misreading what your CEO said? She says, we did a market survey, what other places were charging, and we charged. We didn't do what you retroactively did, which is break down salaries, and we didn't do any of that. Right? Am I misrepresenting it? Because that to me is a very important fact.
The community fee is described as intending to cover those 4 categories.
Right.
Arguably, it falls short of actually covering those categories because the cost of these payroll, headcount.
I get what you did after the fact, but can it, when your community fee was not calculated this way when you charged it, is it admissible evidence to say, well, we didn't do that? That's not how we came up with this number, but rather, when you told us this is what we should have done, this is what we did. I mean, it just seems like those are 2 different things.
There's no other way to apply Ryan 1 to the actual facts in this case. And because the community fees were commingled with all revenue, there is no other methodology. So the fact that community fees were not required to be segregated, but a decision came down effectively finding that Heritage was required to segregate these fees.
No, we didn't say you had to segregate. We said you can charge for these functions because you said you were charging for these functions, but you actually weren't. You did a market survey and found out what people charge for this, for a sort of a fee. He's going to call it a junk fee. I'm not going to use that terminology, but you guys charged this fee based on what the market will bear, not that it reflected categories that we identified.
So the methodology in which we would, there's no better way to calculate the community fee because it's payroll. So in the years, there's only 5 new residents versus years, there's 30 new residents. There's no way to anticipate what this year is going to look like. So there's no way to reasonably create individualized community fees.
Right, and so you use the market as a benchmark, right? This is what the market charges for these kind of things, and so that's what we're going to say is the community fee. And if it doesn't cover all your costs, so be it. You won't get as many residents.
Yes.
Right?
Well, if it doesn't cover the costs, it just the other revenue will pay. So it's never been. It's not that there's a huge profit on the community fees, and it closely in the exercise we did to show that.
When did you do the market surveys? Was that before you started charging the community fee?
I think it's every 2 or 3 years.
Yeah. So before you start charging it, you do a market survey.
Yes.
Okay.
And what was the market called? Do we have in the record what you were evaluating?
Other competitor assisted living residences.
Competitor assisted
Living
for what purpose?
To see what the market would bear for residents.
For what?
I'm sorry, for community, for the amount of the community fee.
So you did a community fee marketing based on particular components, or did you just do what kind of extra fee can we charge in addition to? Is that going to be in the record?
Is what going to be in the record?
The record. He's going to stand up and say your fee is completely. It's just a fee you came up with to charge people for coming here. It's not broken down into components, nor when you did the market survey did you break it down into components. You rather just looked at what do people charge out there for people trying to get into assisted living facilities. And it's not, I think that's what, is that what your I mean, I haven't read the record on what your marketing survey was evaluating. Wasn't it just what do other places charge? Not what do they charge for onboarding blanket or blank. It was just what do other places charge?
What do other places charge for community fees? And what's not in the record is what the language of community fees in residency agreements for other ALRs. So the actual fact is the clause that is in our residency agreement is identical or very closely similar to many to many ALRs in Massachusetts during this class period. So whether I'm confident that the community fees are described the same way, and so when we look at the market for what other places are charging, it covers the same bundle of onboarding services. There is no practical way to account with the real dollars. The best way to do it is to just look at the market. And the community fee, like in this case, the community fee was $2,800. Monthly rent was $4,000. So it isn't a question of, like a junk fee would be, you just made up a number and you didn't give anybody any services. It's undisputed that it's the assessment process for a potential resident is exhaustive. And some residents have thousands of pages of medical records that need to go through. Some residents want to tour the place 5 times before they decide. It doesn't make sense for it to not be a flat rate because it's impractical for the ALR to implement. But it's undisputed that the ALR is allowed to charge for this. So the question of how do we prove it only came because Ryan won. So how do you prove it except looking at the bucket of money? We didn't know and I don't think that this court said, well, I know this court didn't say in 2019 that we were supposed to segregate the community fee. If that's how else, what methodology is Heritage left with but to look at that big pot of money and show that while we didn't specifically segregate, allocate, we most certainly provided these services and we most certainly incurred these costs, and the costs we incurred exceed the community fees we collected.
Okay, thank you.
Thank you.
Attorney Garrett.
Madam Chief Justice, and may it please the court, Joshua Garrick on behalf of James Ryan and the certified class. Justice George, I want to start with two questions that you asked, and then I'm going to shift to Justice Doar just to clear up a couple of things that arose with my sister's argument. Justice George, you're correct. When we were here 6 years ago, this court gave us a clear articulation of the law. We had differing views on it, and the court defined it. This is a Rule 56 summary judgment issue. There was a specific mandate: go conduct discovery and tell us what you did. And two things happened. First, they didn't do that, as you pointed out. Number two, we did it. We got all the facts. And these facts include not just these market surveys that Justice Kafka is talking about, but it also includes President Kubiak's admission that there were no charges for any of the specific charges that this court announced in Ryan 1 would be permissible. This includes no charge for...
Before you move to that, when she argues that the market survey they did prior to creating this fee was to evaluate these items, is the record going to bear that out? Because that may be important, because if they said, okay, what are other people charging for these services, then it sounds like some of it may be fine. But if it's just a market survey about what do people charge for anything, that's different. But what does the record show on that?
So the record will show, and I don't have the exact citation, but in the second volume, in our statement of facts, we cite to Robert McGuire, who is the controller. We asked him, because there was a reference in the interrogatories to these market studies. So we asked him, what were the market studies? And his answer was essentially, what other people charge for the community fee. There's no testimony, there's no evidence.
What is wrong with that?
What's
the problem with setting a community fee based on the market?
There's nothing wrong with charging a fee based on what the market.
And so why doesn't that take this fee out of the Security Deposit Act?
So there's nothing wrong with charging a fee based on what others charge. There is a problem if the fee has to be shown, if you have to show what the actual purpose and the actual use of the fee is. Because
is there any dispute in the record anywhere that these services were not provided to the residents and potential residents?
So there is actually, and this is what one of the amicus briefs wrote, that there's no dispute that these services were provided. There is no statement, there's nothing in the statement of facts that suggests that these services were actually provided.
Are there anything in the statement of facts that say that these services were not provided?
No.
Okay, so there's a material dispute of fact.
Well,
seems to me that you don't get summary judgment on that.
Well, I think what the court did is they assumed that the services were provided. And let's be clear, the statute says that that you have to do an assessment and you have to do.
Your position has never been that this assessment was not done.
I don't. That's not our argument that the assessment wasn't done.
I'm sorry that. So you concede that the assessment was done? Is that?
Well, there would have had to have been an assessment, otherwise my client wouldn't have been.
So again, it's undisputed that there was some sort of ALR-related services performed.
Yes.
Okay.
Can I go backwards for a second? Because you agree that it's a community fee. We know what I don't know what a community fee is. I know what onboarding services are. I know what the other three categories in. I mean, is a community fee understood in that world to be those categories? And excluding maintenance, Justice Doar's question, that's to, because that may be the whole case here. So what do we know about that marketing and what that community fee was defined as?
So if the question is the community fee itself an industry standard, I guess is what you're saying?
Is it commonly understood what the community fee is for? Like, these places provide all kinds of things. They provide French classes. They provide, bus trips to places. They do all kinds of stuff. But the categories that were listed in the community fee, was that what when they did that marketing survey, are we going to be able to connect that to those 3 out of those 4 things that we thought were fine?
No, the only thing that you're going to connect is that they were looking at what other people were charging. There's no
Charging for
the community for some sort of upfront community or administrative fee, whatever one facility decides to call it versus another. That's what they were looking for. What can we get away with, essentially?
But what we can get away with and a community fee may be 2 different things. What we can get away with is impermissible. But if it's understood that they were charging for basically ALR specific community fees, that may be appropriate. Right?
Yeah, but we know that they weren't, because we asked them, what were you charging?
They said they didn't segregate it. They didn't charge for the specific.
No, Justice Kaffer, they went beyond that. Okay. They were asked with specific reference to each one of these ALR specific services identified in Ryan 1, including others that weren't identified in Ryan 1 but were identified in statutes. They were asked, what is the cost? In each instance, President Kubiak, initial patient screening, no charge. Application process, no charge. Updated service coordination plan, no charge.
So they were providing these services?
They were providing these services and they were not
free?
charging. Yes. There was no charge to
your position is that they were providing these services required of an ALR and they were doing so gratis?
Yes. And
that's what the summary judgment record will show indisputably.
The summary judgment will show that President Kubiak admits that there is no charge for any of these services.
There's a difference between admitting that there is no charge for ABC and performing services ABC and receiving monies for those services, right? And so I don't, the record better than me, but you're saying that when I look back, there's going to be an absolute undisputed statement. We were giving these services away for free, even though we did the market surveys and we saw what other people were charging. We were just going to do it for free. Yes. And that's undisputed.
Yes.
Okay.
So that's a disconnect, though. So why would they do the marketing survey to find what people were doing if it didn't, and then they weren't going to? I just don't understand what the logic would be. Why would they do the marketing fee for these services, charge it, but then give it for free? I just don't understand the logic of that.
They weren't doing the market analysis to determine what they were charging for the services. They were doing it to determine what they could charge for a community fee. And I'm going to do what you told me not to do. The reason why they did these market surveys was to determine what can we charge as a junk fee. That's what we have here.
Can I ask a question? And it may have a couple of different components, so I apologize for that. The first is, it hinges on what was said in, I'll call it Ryan 1. And I read the holding to say that the permissibility of the community fee will hinge on a determination of 1, the actual purpose and use of the fee, and 2, whether such purpose and use are for distinctive ALR specific services rather than general maintenance or other aspects of a generic residential tenancy. My first question for you is, do you understand that to be the holding of Ryan 1?
Yes.
My second question for you is, it seems to me that you, as the plaintiffs, have the burden of proof to show that you meet that standard. Do you agree with that?
No.
Okay. That seems odd to me, but let's go past that. You are the plaintiff. Whoever has the burden of proof, someone had to, on summary judgment, establish that there was no triable issue of material fact with respect to either the purpose or the use. Now, I hear most of the argument going on here with the purpose of the initial imposition of the community fee. And that seems to me to be a separate question from what the summary judgment record reveals with respect to the actual use of those funds. I also think that we can all agree that the analysis the trial judge used in deciding the motion for summary judgment may not have been correct because it seems to hinge on segregation and some notion that money is not fungible. So, what I read the summary judgment record to permit is a conclusion that a triable issue of fact was raised with respect to the actual use of the community fees. Can you tell me why that's wrong?
Yes. First of all, Judge Mulligan specifically said in her decision, this is not about segregation.
Right.
She writes, Heritage is correct.
I saw that.
Yeah. So
Actually, for summary judgment review, it's de novo. It doesn't really matter what she said. We just look at the summary judgment record. So my question is, why is there no triable issue of fact raised regarding the actual use of the community fees?
Okay, so two things. So we presented our facts. President Kubiak's admission that there was no charge, the capital budget report showing that shaded gazebo, walkways, things that Justice Kaffern.
That doesn't have anything to do with actual use. It's a different point. I'm asking about actual use.
So the actual use, we showed that the money that was deposited were used for these services. The actual use that was offered by the facility was the salaries. And this was going to go back to Justice George's second question that I wanted to answer. There is no admissible evidence in the record, but they had.
Why can't an employee get on the stand at trial and say how much of her time is spent doing what?
Well, for several reasons. First, it was a post hoc determination.
That doesn't matter. I mean, for purposes of admissibility, with all due respect, someone can always testify about something they did in the past. So, what rule of evidence would preclude a person from testifying to that effect?
I think the answer to that is there's no rule of evidence, but the rules of summary judgment prohibit it because you can't create a.
Was it in the form of an affidavit?
No.
Was it an answer to interrogatory requests?
There was a spreadsheet that was attached to the interrogatory that was drafted.
Okay, so interrogatories come in on summary judgment records.
But this was something that was drafted by counsel. We had asked.
Are you saying it was not sworn to by the client?
It was an addition. It was added on as an addendum to the answers to the interrogatories.
And the interrogatories were not sworn to by.
No, they were.
Okay, so they adopt the addendum.
I'm sorry, what?
The client adopted the addendum.
That was created by counsel, and then when we asked at depositions about how it was created, it was just
right. So that would go to the weight, but not the admissibility.
So,
but this is important because my memory of the record was the affiant was adopting a bunch of other people, the percentages that were ascribed to a bunch of other people. The percentages were a list of employees,
right,
and what they claimed were the percentages. But it wasn't, each affiant wasn't, I do this and it's my percentage, I do this, it's my percentage. It's one person saying, here's a list of all of these other people and what we've determined to be the percentage.
Right.
And who is that person? Who is the affiant?
So my understanding is that the person who signed the interrogatories was Robert McGuire, the controller.
The controller, so in a position to know.
Sure. I mean, we don't know.
This is again on summary judgment, and your obligation in order to win is to show that there is no dispute of material fact.
But again, this is not the appellate issue that was raised by Heritage in this case. Their issue is that there was a disputed issue of fact that needs to be tried. Their position is that this court surely didn't create this obligation to segregate. So respectfully, if that's the
well, we didn't.
No, I understand that, right? But that's their argument.
Wasn't your argument?
They've waived
Wasn't
this
your
idea
argument
that
your argument was that the fee was a junk fee and that it wasn't calculated to determine these items. It wasn't that they couldn't retroactively charge. I mean, what, right? But the problem I got is it comes back to that they did a marketing survey on community fees, and I'm troubled that that may be where the judge may have made a mistake here. May have.
We don't think that there was a mistake, and I think that I just want to briefly address the burden of proof because it was raised. This is a situation where Ryan 1 essentially created a affirmative defense or a carve out, in which case the burden would be on the defendant to prove it, which obviously they didn't. Now we've met our prima facie case that this is beyond the 4 charges permissible in the security deposit statute. It violates anything. We met that burden, and this court has routinely held that where one party has facts that are peculiar, justification peculiarly within the scope of the defendant, then the burden of proof is on the defendant. And when you look at,
they're going to argue 2 things combined. We did a market survey, if the record supports this. We did a market survey on community fees. Community fees are understood in this world to include onboarding blank and blank. And furthermore, we've done this retroactive analysis. These guys did more than that amount of, the director of community, whatever relations, 100% of her time exceeds that amount. So we gave them a deal, essentially. And is that not a triable issue of fact?
It's not. I don't think this court needs to go further than the building reserve funds, which is kind of what the court did below. And to answer Justice Dewar's question, their responses in volume 2, page 16 about the capital budgets. We wrote that includes generic non-ALR construction projects, and then we listed them. Their response was undisputed that the capital budget includes non-ALR projects, but then they dispute that the list had no other that the list had no elements that were ALR specific. But what they didn't do was cite any other fact, which you're supposed to do under Rule 56 and 9A. They didn't cite any other facts to support that conclusion. So from a summary judgment standpoint, this is, as Judge Mulligan found, dispositive. And all we need is just $1.
So all you need to prove that as a matter of law that they're liable for the full cost of the entire community access fee is that at some point from their general account they paid for capital expenditures?
And not only that, they listed it in their residency.
Sorry, that was a question though. Do you think that they cannot win if they ever spent money on capital expenditures?
Yes.
Regardless of how much they spent actually providing the services they're required by the regulation to provide?
Yes, and here's why. Because
isn't that inconsistent with what we said in Ryan, which is these 3 things may be okay, this 4th one may not be. And it sounds like we're exactly where we were at Ryan 1, which is we can't figure out on this record the answers to those questions.
Maybe. There's one other thing that I don't know that I can figure out from this record is, so Heritage is saying we were never tasked to do this in the first place. So when it got punted back from Ryan 1, we're put in a position where we have to do this after the fact because we never had to affirmatively do it. But there were a couple footnotes in the decisions that talked about the CMR. And so one of the things that I can't figure out is, did the CMR actually require them to itemize this in the first instance? And can you talk about this and can you give me some specifics? Because that's what I couldn't figure out, because there was another amicus that said, hey, if you do this, make it prospective because we never had to do this in the past. But did they actually have to do this in the past? Like they could charge the community fee, do the market survey, but they were still tasked with saying we've got to tether that to what we're actually doing because of this.
Yes, and you're absolutely right. 651 CMR 12.08 subparagraph 2A9 is clear. If you're going to charge someone something for on a fee for service basis, which is what this court said in Ryan 1 that you can do as long as you're, and the statutes say these are fee for service basis items, then you must itemize. You got to give a description of what it is and what the cost is. You can't just lump it into this this community fee. And Justice George, that kind of goes to the point is that they're making this big deal out of segregation. That's not our issue. Our issue is itemization. If they had done the work before, then perhaps we could see that, yes, this was exactly what they said, but they didn't. They didn't do it before. They were required to do that. And on top of that, when we asked them what's the cost for it, and they say 0, and we see the capital expenditures, and we see the market survey studies, we see the residency agreement, which says that it includes things that are impermissible, there's no question that this is a situation where the burden has met, whether it was our burden or their burden. Judge Mulligan said that it was our burden. She said that we conceded it was our burden, but I don't recall doing that. We think it's theirs, but she said it was our burden, and we met it. So the facts are one-sided. The itemization requirements there. For those reasons, this court should affirm.